Welcome to the video lecture on the courts. All right, so courts, we're now into talking about the American criminal justice system, where we go into cops, courts, and corrections, and we're talking about courts today. So courts and the Constitution. So courts are charged with interpreting Constitution. So judges on the United States Supreme Court interpret the U.S. Constitution. And ever so often you'll hear me refer to the U.S. or the United States Supreme Court as SCOTUS. So that is just an acronym for the U.S. Supreme Court. So judges on state Supreme Courts interpret state constitutions. So we have what we call a dual court system. So there are two systems of courts. We have state and federal court. Each state's court system is sovereign jurisdictions. Federal courts are distinct from state courts. So federal courts have limited jurisdiction over state courts. And you have also the 10th Amendment, which states that the states have responsibility and power to establish their own court system, including codes of civil, criminal, and public law, as well as civil and criminal procedures. All right, so when we compare federal and state courts, we have the U.S. Constitution is the supreme law of the land in the United States. It creates a federal system of government in which power is shared between the federal government and the state's government. So due to federalism, both the federal government and each of the state governments have their own court systems. So discover the differences in structure, judicial selection, and cases heard in both systems. So depending on what state you're in, you're always going to have your state Supreme Courts hear something before it goes to your federal United States Supreme Court. All right, so here's a look at court structure. So I'm not going to read these to you, but I ask that you make sure you pause here and you read through and understand the difference between the federal court system and the state court system of these next few slides. All right, and then we have the selection of judges. So again, the federal court system and the state court system. So in the federal court system, the Constitution states that federal judges are to be nominated by the president and confirmed by the Senate, which just happened. Also, they hold office during good behavior, typically for life. Through congressional impeachment proceedings, federal judges may be removed from office for misbehavior. In the state court system, state court judges are selected in a variety of ways, including election, appointment for a given number of years, appointment for life, and a combination of these methods. All right, so types of cases heard. On the left, we have highlighted around in red the federal court system. Cases that deal with the constitutionality of the law. Cases involving the laws and treaties of the U.S. Cases involving ambassadors and public ministers. Disputes between two or more states. Admiralty of law, bankruptcy, and habeas corpus issues. And then on the right, highlighted around in green, you have the state court system. They hear most criminal cases. Probate, that involves wills and estates. Most contract cases, tort cases, personal injuries, family law, marriage, divorce, adoptions. State courts are the final arbiters of state laws and constitutions. Their interpretation of federal law or the U.S. Constitution may be appealed to the U.S. Supreme Court, and the U.S. Supreme Court may choose to hear or not to hear such cases. All right, so this is something that you will see again on a quiz. I may ask something like, how many U.S. Supreme Courts are there? Well, there's one. How many U.S. Courts of Appeal are there? There's 13. And how many U.S. District Courts are there? There's 94. And then we're going to go through each one of these. So we're going to start with the U.S. Supreme Court. Again, the U.S. Supreme Court is the highest court in the United States. There are 9 justices on the U.S. Supreme Court. So you might see that again. I've put a link there if you want to learn more about that. If you're a CCJ major, you're going to go on to learn more about that within your major, which is really cool. All right, so how do cases come to SCOTUS? So remember, SCOTUS is the United States Supreme Court. Well, this is just kind of a little tutorial map that kind of shows you how it gets from different parts of lower courts or trial courts, and it goes through your state Supreme Courts and appeal courts, and then, or a special federal court, and then it can make it up through to SCOTUS or the United States Supreme Court. All right, now we're on to one of the 13 U.S. appeals courts. So this is just kind of a look at the United States where those 13 appeal courts are located. So depending what state you're in, that's where, if you go to an appeals court, which one you'll go to. And then we have 94 U.S. District Courts. And this is just kind of a look at each state forms at least one judicial district with at least 2 judges. Larger states are divided into multiple districts, and larger districts may have more judges. And there are 94 district courts serving all 50 states as well as U.S. territories. And there are 632 district judges. All right, so are courts here for justice? Yes, no, maybe, or what? What do you guys think? How do you answer in this? Circle one in your mind. Well, justice means different things to different people. I bet all of you kind of answered something different. I bet we all didn't answer the same. A victim of crime would be interested in the outcome. So, for example, if somebody had been robbed, or if somebody had been in a vehicle accident where somebody driving drunk had hit them in a car and they had been paralyzed, they might be interested in, getting even. Whereas if a person was accused of a crime, they might want to be treated fairly and impartially. So true justice is both about process and about outcome. So the role of the judge, what is it? Well, at trial, the judge acts as a referee and a teacher. They're expected to be impartial between both the defendant and the prosecutor. They're supposed to be not too closely interested in the facts of the case, but in how the legal and ethical each sides are behaving. And throughout the trial, especially at the end, the judge acts as a teacher for the jury, explaining complicated points of law, and at the end giving them an hour or so mini lesson in the law before the jury deliberates on the verdict. All right, so what we're going to do right now is, I'm assuming that a lot of you, and not even totally me, even as a cop, I go out, I understand what happens to make an arrest, but what happens after you're arrested? Because as I've told you, the American criminal justice system, those 3 different prongs, the cops, the court, and the corrections, they're all very separate, and they should be separate so that there is a balance in what happens. There is a check on power so that we are always ensuring that one person isn't controlling everything. So what does happen? I mean, if I were to go into a 7-Eleven, I don't have any money, and I use a toy gun to hold up the cashier and take the cash out of the register, and a cop responds and arrests me for robbery, what happens? Well, let's see what happens. So these are the steps, and you do need to know these steps because you're going to see this on a quiz. It says, what happens after arrest? Well, it's what's called a first appearance, and we're going to break these down just so you know, but you do need to know these steps. There's a first appearance, there's a preliminary hearing, there's an information or indictment, there's an arraignment, there's an adjudication, and there's a sentencing. So basically what happens is, me as the cop, I would go out there and I would look at all the facts. I would say, do I have probable cause to make an arrest? Do I believe that this person, do I have enough evidence? Did the witnesses say, what's my evidence? Do I think this person did it? Is there any video? What's the evidence? Okay, yeah, okay. I'm going to move forward. I'm going to make this arrest. Okay, so then I make the arrest. I take this person to jail, and then that is it. I go on, I do my job, and now it's in the court's hands. Okay, so we go to the first appearance. So if you go back, we're at that very first step, first appearance. You see what's highlighted? Okay, so now the cops are out. They'll come back in if they have to testify, okay, if it does go to trial. But if there's going to be a plea bargain, the cops are done, and I'll never hear about the case again. But now we're in the courts. So first appearance. So within hours of being booked, the suspects are brought before a magistrate, the judge, and they have their cases heard. And basically, it's so the judge can set bail, and it's so they can get counsel so that they can know what's going to happen. Often at this point, it's clear that the more money that you have, the more freedom you have, because obviously that's how bail is set. All right, now we're at, if you go back to here, we've done the first appearance. That's where you see the judge. They know what crime is. They said what crime the person's been arrested for. Now we're on to the preliminary hearing. All right, so the judge looks at the probable cause. What did the police say the person did? Okay, and the judge says, okay, did the officer have probable cause? Was there sufficient evidence? Is there a connection? Did the police do the right thing? And remember also, at this time, the police should have had a supervisor, I used to be a supervisor, looking over the report as well, making sure that the arrest was good. All right, now we're on to the next step. Information or indictment. This is where the prosecutor with the court, so now the judge has looked at it and said, because the judge could stop this and say, oh, there's not enough information, there's not enough evidence, so the judge could release the suspect on saying, no, I don't like this, the cop didn't have enough probable cause, and can stop it and release the suspect, or can continue on. If it continues on, this is where it goes to the prosecutor with information or indictment, and the prosecutor reads the case and says, okay, I think there's enough probable cause, but I want it to go to a grand jury. And this is where a grand jury reads the case and determines whether or not there's enough probable cause. Reads what the cop did, reads what evidence there is, and says whether or not there's enough probable cause to continue on, to make sure, hey, we need to make sure this is being fair. We're being fair to the person. All right, and then if the grand jury sends down a true bill, which means, hey, they think there's enough probable cause that the person, there's enough evidence there to move forward, they're going to set an arraignment. So this is the first public appearance that the defendant has in open court. Okay, this is where the accused must stand and listen to the indictment. It must be read, their identifications confirmed. The judge is going to ask whether they have legal counsel. And the judge wants to hear one of three things: guilty, not guilty, or no contest, no low contendere. This is where a lot of times plea bargains are entered. In fact, 90% of the time, this is where plea bargains are entered. This is why, as a cop, if I made an arrest, I never hear about the case again, because plea bargains are entered. Okay? Now, if a plea bargain's not entered, this is where we go to adjudication. So this is where we would go, if there's no plea bargain, where we would go through trial. We start going through trial. Okay, we're going to start moving forward. And it's expensive. So that's why we want, a lot of times, plea bargain. We want to say, hey, you're charged with robbery because, you robbed the store, but we'll mark it down to this if you take a plea bargain. And if I take a plea bargain, it goes right to sentencing, or it goes to the jury trial to be found guilty or not guilty. If I'm found guilty, it goes to sentencing. So there you go. We just went through the whole thing. If you go back to this thing, it went through that whole entire thing, what happened after arrest, through that court process. So now you know. Isn't that amazing how much you learned? Now, obviously, we just went through the super fast Zoom portion of it, but here's the constitutional rights of somebody that is arrested for for a crime. So make sure you know and understand these, that they have the right to an attorney, they have the right to know their charges. So make sure you pause here and know those rights. All right, so a defense attorney, a question. If you have a video of a person that kills or rapes a victim and that person pleads not guilty, what are some reasons why it's good that that person has a defense attorney? So what do you think? If there's video of that person committing the crime, why is it good that they have a defense attorney? Well, let me tell you, because it's that checks and balances. We want to make sure that their constitutional rights are held up, that all their rights in courts, that the evidence, the rules of evidence, that all those rules are held up, that the prosecutor, the judge, that everybody is doing everything right. That's why. All right, so the bail system. This is another important part of court that you want to make sure you know about. It's usually done within 48 hours, according to the McNabb rule of an arrest. And as I kind of covered earlier, the resources of a person on whether or not they can afford an attorney is important. The original purpose of bail was to ensure a person's return to court. So that they wouldn't go away. So if I was arrested and they wanted me to return to my hearing, they would take money from me. So nowadays, the Eighth Amendment doesn't guarantee bail, it just prohibits excessive bail. So that's what the Eighth Amendment does. So you're going to see some matching questions coming up asking what the Eighth Amendment is, and Eighth Amendment prohibits excessive bail. Oh, we also have what's called ROR, which is called Release on Recognizance. And it basically means defendants facing minor charges with no criminal record and strong community ties usually will receive pretrial release, also called Release on Recognizance, which is a promise that they will appear in court when later required. We also have an Illinois plan, which requires only 10% of the amount of bail be put down. So what that means is a lot of times you'll hear bail bondsman, which means you'll go to a bondsman and they will put up the whole bail and you only have to put down 10%, but you secure it with something else, such as you own a car, so you put the title to the car, or you take out a second on your home, same thing. Or you'll hear about somebody skipping their bail. That's where a bail bondsman will come get you. All right, so preliminary hearing and grand jury. You heard me talk about what's a grand jury. Well, a preliminary hearing or a grand jury isn't like a jury trial. So a grand jury is just where they are hearing the facts of the case to make sure there was enough probable cause, enough evidence to move forward within the case to go to trial. All right, so I'm going to leave you with this. It's just something to think about and how serious it is. So have you ever been accused of a crime, and how would it impact you? So many people just think one kind of tentacle, I'll call it. But think about this. If you were ever accused of driving under the influence of alcohol, before you get in the car the next time, if you have ever had something to drink, not only would it influence you if you were arrested socially, but legally and financially, because if you are arrested and if you are convicted of that DUI, you have to carry what's called an SR-22 on your insurance for 5 years. There's lawyer fees, there's driver's license fees, there are court costs. They say it could cost you anywhere between $10,000 to $20,000 just in all those example fees to the left. So it's an expensive thing financially, and that's just a DUI. So it's a huge thing when you talk about going to court, and that's just something like a misdemeanor. All right, that ends this